let's start. So, hello everyone. Thank you for joining DataCon LA 2021. This is the last day. So welcome to the AI, Machine Learning, and Data Science track. I'm your host, Stephen. Our co-host today is Reza. We'll be moderating the chat and the Q&A for you during this session. Today, our guest is Morvareed Salehpour, and she will be talking about top tips for AI, ML businesses to avoid legal pitfalls. So a little bit about Morvareed. She is managing attorney of Salehpour Legal Consulting, which is a law firm specializing in assisting entrepreneurs, startups, and businesses to create and negotiate the strongest contracts and tech transactions for scaling and protecting their businesses and startups. She is a graduate of the UCLA School of Law, where she was managing editor of UCLA Law Review. And she previously practiced at the firm of Baker Hostetler, where she was a member of the legal team seeking to recover the principal lost in the Bernie Madoff Ponzi scheme. She is also president of Santa Monica Bar Association, board member and career chair for UCLA Alumni Westside Bruins Network, and board member and co-event chair for UCLA LA Law Women Lead, as well as a regular speaker and writer on issues in tech and business law. So quite an impressive resume. Without further ado, I'll hand this over to our speaker. Thank you for being here today, Morvareed.
Thanks, Stephen. I'm glad to be here. So today I'm going to be sharing some top tips for AI, ML businesses to avoid legal pitfalls. I'll leave like the 10 or so minutes at the end for questions from the audience. So please hold your questions and I'll get to them at the end. As a first kind of thing, everything that I'm going to be sharing today is purely educational. So none of it is legal advice. If you need specific help, please feel free to reach out to me separately afterwards. All right. So one of the first areas that business AI and ML businesses have issues with and need to make sure that they are not getting in trouble with is around commercial contracts. And these are some of the typical areas that these type of contracts come into. So there are founder agreements, which are a big area that's important at the start. So if you have, co-founders, you're starting the business with another business, or you're starting it even by yourself, it's important to get the right agreements in place. So for corporations, this is in the form of bylaws and shareholder agreements. And for LLCs, this is in the form of operating agreements. So business founder disputes are a common issue that arise in lots of businesses and actually put a lot of businesses out of business. That is why it's important to have a right agreement in place at the beginning. And I can kind of, similar to these worker agreements, independent contractor, consultant agreements, and employee agreements are also important because they not only establish the role of these other individuals in the business, but they also establish rights around intellectual property that's being created. And in AI ML businesses, intellectual property is the real value of the business. It's its asset. So you need to have clear ownership around the intellectual property. And I'll use a specific example of how this has gone wrong before that I've seen. So for this specific example, there was a business that I was working with, and the business had actually hired a consultant that they had worked with, and they had worked with each other over a decade, creating different products and intellectual property. And then, a recessionary period happened. They weren't doing so well. So the consultant actually took the valuable asset of the property, the IP, and ran off. That IP was probably worth a couple $100,000. The business decided, they weren't really going to pursue that because that revenue stream was probably going to end in like a year, and they were going to work on some new revenue streams. They came up with new offerings, and within a year and a half, the business was making multi-million dollars in revenue. Guess what happened? The consultant came out of the woodwork and said, everything you're working on is half mine. I am a partner in all of this. I own half of it, and I'm entitled to half of the revenue and the equity in the business, all of that. Well, the problem was the business had not put into place an agreement with the consultant at the beginning. So it became a situation of he said, she said, and they were litigating this in court, and they did litigated it for almost 2 years and finally resolved it on the eve of trial for a settlement of a large number. And this is all something that the business could have avoided if they had just spent, they ended up spending hundreds of thousands of dollars on legal fees and all of this. And this could have all been avoided by spending a couple thousand on getting the right agreements in place at the beginning. So you need to be putting in your forethought as a business to be investing in those appropriate agreements that establish the relationship between all the parties on the front end before things go wrong or before people are able to come and create this ambiguity around what is actually the situation. Other types of common agreements are customer agreements, particularly say you're making some kind of SaaS or software offerings, or SaaS or software agreements. There's service agreement portions of it. Sometimes it takes the form of subscription agreements. There's also often data processing agreements that go into play in the business because you're dealing with data when you're a AI ML business, and terms of service are another form this takes. These are, again, very areas where businesses can get, AI ML businesses can get into a lot of trouble because as an initial matter, depending on what you're doing, the business is often doing something that is in a new emerging area. So these documents are things that need to be very tailored to the business. It's not a cut and paste situation. There's also the situation where you need to make sure that the right relationship is being established with the customer and that you're getting the appropriate rights to actually even make your product work. So another example that I have seen go wrong in this situation is that you'll get, the business will have some kind of agreement that they have, at least they've invested in getting a template set up, which is important. You get the template set up by your attorney, and then you share it to the business people, and they're going out there and they're negotiating agreements and working with potential customers. I've seen multiple situations where I've had clients, their business people come back and they're like, here's this agreement we've negotiated with the other side, and I review and start going through to make sure it all makes sense. And there are provisions in there that actually don't make sense, particularly around data. So there's been multiple situations where I've had to stop a client from signing an agreement that actually had provisions in there that would have prevented their algorithm from working. So that is a particular complexity with AI ML business. There are certain provisions that have to be contained in the agreement, certain language particularly for every type of business to make sure that the algorithm can work. And if the language is not there, then algorithms can't work and you're going to be in breach from day one. And that's not a situation, that's not a tenable situation. Like being in breach of your customer contracts from day one just because you didn't negotiate the right thing is really a big pitfall. So that's why you need to be very cognizant about both the agreements you're getting structured in the first place, but actually in negotiating these agreements. And I've had to, often educate the opposing party, opposing counsel about this, as well as the business people at my clients as well, because it is an area where a lot of people don't have the education. A lot of attorneys on the other side, because they're not specialists in this area and in tech, they don't understand it either. So it often involves educating them about why this deal has to be structured in a certain way to actually make the offering that the business has work. So that is very, very important in any of these businesses. Other common commercial contracts are similar forward to the customer agreements, but in the vendor side, right? So as an AI ML business, you are generally in a data chain. So you are dealing with both your customers, but you also have vendor agreements. And those also take the form of, service agreements, SaaS and software offerings, data processing agreements. This is another area the business has to be very careful in, because particularly if, for example, your vendor has some kind of issue or breach, that will also reflect on what you are liable to your customers for. And, I'll share a particular example of this again. I've recently had a client whose vendor suffered cybersecurity attacks or cyber attacks. So they suffered multiple cyber attacks. My client suffered not only cybersecurity issues, but also business interruption and disruption issues. And that affected the operations of their business and their relationship with their own customers. And part of the complexity was we are, negotiating a resolution with the vendor to all of the fallout from this, but they didn't get assistance in negotiating those vendor agreements at the front end. So the provisions in there are not as strong as they should be around these concerning areas like data and cybersecurity and privacy and all of that. So as an AI ML business, particularly when you're dealing with data and you're dealing with vendors, you need to make sure that you're protecting yourself on both sides of the data chain, because data breach, cybersecurity issues are some of the largest liabilities that a business can face, and it could put you out of business if you don't have the right contractual provisions around all of that. And another thing to make sure that you are also getting as protection for all of that is insurance, making sure you have the appropriate insurance in there too. And then the agreements also have the appropriate provisions around insurance in them as well. Other areas that we see common kind of commercial contracts and issues come up in is business partnerships. So these often take the form of strategic alliances, joint ventures, referral agreements, reseller agreements, subcontractor agreements. This is, again, an area that a business has to be very careful in how they operate. So it is always exciting and great to be looking at new ways to scale a business, to create new offerings, to have new opportunities. But they still, as a business, as an AI ML business, you still have to take into consideration the legal implications of all of that. So I'll share a couple examples. I had a client who was going through a government contracting process, and I was assisting him through that. Well, they were very excited about, moving forward and all that, but government contracts have their own types of intellectual property provisions, and all of that has to be analyzed and reviewed and negotiated the right way, because you may end up in a situation where you end up basically giving away your intellectual property to the government, or giving them rights to do whatever they want with it. And that actually hurts the value of your business. Again, intellectual property is the biggest asset that any business has, particularly tech businesses, particularly AI, ML businesses. So if you're not appropriately protecting your intellectual property, your trade secrets, and unintentionally giving those away or giving away ownership or rights to them, you end up devaluing your business. So if you want to have a sustainable business, you need to be aggressive in the contractual provisions and really understanding how you're structuring all these agreements. Another similar situation, that's come up for multiple clients is they start structuring their agreements with customers or with new potential strategic partners to create some kind of joint or new offering. And intellectual property again comes in. So I've had multiple situations where clients have looked at joint offerings and they have had a kind of unclear term, their initial thing they presented to me has had unclear terms around intellectual property. Again, when you're creating some kind of offering, you need to be clear about who owns what, so you can actually monetize that intellectual property. Again, that's where you're getting your revenue from. That's where you're going to get investment. That's where you're going to get acquired off of. So you need to have clear ownership around IP. I've also seen the situation come up often where businesses are very excited about doing a deal in a new way. They may have a larger, like a Fortune 100 company who's looking at them, that's offering some kind of deal to move forward with their offering, but maybe in a different way than they have moved forward with their customers in general. And this is a common issue that often comes up that I've seen is around open source. And there are so many situations where business doesn't do that analysis. So I have had multiple situations where a client is kind of pushing to move forward with a deal. They haven't really done the analysis until they come to me, and it's I've had to basically save them from unintentionally open sourcing their software. So when you're dealing with, incorporating open source, due diligence needs to be done. You need to be doing that analysis with your attorney to figure out, hey, are there specific concerns I should be worried about? Because you don't want to be in a situation where you unintentionally have your proprietary software become open source, because again, overnight, your business is essentially becoming valueless because you haven't taken the proper precautions and put the proper investment to protecting that intellectual property. So, what are some of the pitfalls with contracts, as we've been discussing some of them? So we have no written agreement. We talked about like the situation with the business with the consultant. Use of agreement forms from services like LegalZoom. Again, this is, as we talked about, particularly with AI ML businesses, these are not cut and paste situation. They need to be tailored to every business to make sure that the appropriate rights are being established, appropriate liabilities, appropriate provisions around data breach, all of that. Otherwise, the business will not be able to actually operate its offerings properly and will be facing larger liabilities than it needs to be. We also have agreements. The other kind of issue is agreements written by non-attorneys. I've seen this a lot. This is similar to the issue with using the kind of forms or templates or not having an agreement. These are never sufficient. I had a situation recently where I was dealing with a client who presented me with an agreement they prepared for a strategic alliance. They had someone who was saying, a business person who'd seen contracts before, but that wasn't sufficient. Their agreement was actually nonsensical. And if they had moved forward with that, they would not have even protected their IP under the provisions of their agreement. And it had, joint IP being created, so they wouldn't have actually had rights to any of that. So I was able to revise that and actually create a contract to protect them. So again, you need actual experts involved. The other common pitfall I see is delay in attention to contracts in not putting in the proper investment from the beginning. So it's important to get these agreements in place from the start. And you can, like I prioritize with my clients, right? We can say, these are the 10 agreements you need, or this is the 5 things you need. Let's do the most important ones are like 2 and 3. Let's do these now. And then we'll come back to the rest, in a couple months when you have more of a budget. But you do need to start to attend to these, and you can't just kind of ignore it and hope for the best, particularly since so many of all these agreements, their kind of central point is protecting intellectual property and monetizing IP. If you're not doing those the right way, you don't actually have that asset, valuable asset. Another common issue is no signed agreement. So sometimes the businesses get their agreement prepared. That's great, but you actually have to move forward and use that agreement. So there have been multiple situations, such as I had a client not too long ago who had a situation where they had a customer not pay, and we were going to pursue that situation, try to get it resolved. And one of the complexities with that situation that weakened their claim was when I asked them, where's the agreement that you guys entered into? It was, well, we have this, but it was never signed. So not only get the agreement prepared, but make sure it's actually being used. Make sure every party is signing it. And that ties into the next point. Make sure you're maintaining the contracts and business records in a clear way. It is unfortunately too common. I've talked to a business, again, has had some kind of dispute arise. And when I've asked them, where are the agreements at issue? They don't know. They're like, oh, I need to go try to find it. You shouldn't be in a situation where you don't know where your agreement's on. You need to have a clear record of all of that. The other kind of really, big mistake I've seen businesses make with contracts is cutting the attorney out of key parts of deal negotiation and papering. So I, for example, had a client who was doing joint, kind of creating a new company as like a joint venture with some new technology. They, sent me the kind of founding agreement, and I helped them revise that, all of that. And they, we send it back to the attorney. We're waiting for their comments. Without talking to me, they separately went and basically talk to that attorney and sign their agreement, and then they forward it. Then they ask the attorney. They were trying to, they decided they wanted to not pay legal fees, so they were just asking the attorney, "Oh, is everything I want it in there?" And the attorney's like, "I'm not your attorney." So they forward it to me, and they're like, "Oh, is everything I want it in there?" I'm like, "Well, at this point, no, it doesn't look like it, because you apparently signed it, even though I told you not to sign it until we finished negotiating, because you wanted to cut me out." So that's not a situation you want to be in. You don't cut out, you engage an attorney to help you. You don't cut the attorney out of the deal because you want to, try to cut corners. That's not how you're going to protect your IP and protect your business, by trying to cut corners. You really need to make sure you're making the proper investment to get that protection on the front end. All right. So what are the results of neglecting contracts? So as we talked about, there's confusion around intellectual property ownerships, this creation of unnecessary difficulties for contract performance. There's lost revenue because you're not getting the right relationships in place with customers. For example, I had another situation where a business had decided to cut and paste some customer agreement from the internet. They saw some Fortune 100 company was using it. So like, oh, well, they have great attorneys. Like I'm going to use them. That again, not applicable to their business, and actually payment in that agreement was conditioned on approval of a third party that was not involved in the transactions of this business. So guess what? The customers of the business had taken advantage of that loophole and were saying, "Hey, we don't actually owe you money because this third party has not approved payment." So the business was losing out on tens of thousands of dollars a month because they didn't invest a couple thousand to put that right agreement in place at the beginning. Overexposure to burdensome and non-standard obligations and liabilities. We kind of talked to this about. This is often around particularly different liabilities and cybersecurity things, not getting the proper provisions in place, both on the vendor side and in the customer side, opens you up to the large liabilities. We talked about putting a business out of business. There's increased disputes and lawsuits that a business has to face when there are unclear terms around all of this. There's greater stress and legal costs to address. It's always a lot less stressful and less costly to address this on the front end than when things have gone wrong and having to do a situation to clean up. And there's decreased valuation at acquisition. For example, I've had multiple clients go through acquisition recently. We're doing the due diligence. It's come out there's some agreements that have been entered into that have not been escalated to legal, and there were inappropriate terms around obligations, liabilities, all of that in those agreements the business people had agreed to, and all of that created a situation where valuation was decreased and there had to be resolutions paid out to customers, which also created a double kind of financial whammy. So that's the other to think about. All these contracts, the processes and procedures a business puts in place around this have long-term consequences. So they create a situation where not only do things go wrong now, but they also, affect the investment, because due diligence is going to be done at there, as well as acquisition, as due diligence is also done at that time. So you need to think about the long-term consequences of all of this. Intellectual property, as we've been talking about, is another particular area that is very important to businesses in the space, and you need to take caution to protect the IP. So these take the forms of copyright, trademark, patent. As I've said, it's important. It's the most valuable business asset for tech-based businesses. So what are some of the pitfalls with IP strategy? So, the first kind of pitfall is failure to take the steps to register it, trademark it, get the patent for it. And then we have all these kind of examples we've been talking about with the failure to actually have contractual protections and appropriate structures in place with employees, consultants, customers, vendors, partners, prospective business relationships. So you have to realize that AI ML business, the IP protection doesn't stop at getting the IP registered, but it's also putting in place all the contractual protections to actually keep it, protected, keep the ownership retained, keep it confidential, all of that. Tied into that is the failure to take steps to protect trade secrets. So trade secrets are information that are broader than just intellectual property. They're secret information of the business that gives the business a competitive advantage, such as customer lists. So there are multiple steps that a business has to take to protect trade secrets, particularly, again, contracts, putting in the appropriate workplace controls, putting in place appropriate security, making sure, for example, only people who really need to know the trade secrets, things like that, to actually maintain something as a trade secret. So what are some of the results of neglecting IP strategy? So one of the biggest losses is this loss of a competitive advantage in the marketplace. So when you are able to maintain ownership of IP and keep the secrecy of trade secrets, you are the only one who can really use that IP and monetize it. So that's what gives you a competitive advantage. When you lose that in the trade secrets, you lose that ability to monetize, and you have other parties able to monetize that IP because there are multiple parties that are asserting ownership over it. You also have ambiguity around IP ownership created when you don't have those rights clearly established and the ownership clearly established. So that threatens your monetization, revenue generation capabilities, and creates greater potentials for lawsuits, creates potential liabilities. And we've also talked about the kind of potential unintentional transfer of IP rights, such as what we were talking about with government contracts and potential open source issues that come up when you're transacting in a new way. So you need to be kind of thinking about IP and its protection and its monetization in all your transactions and everything the business is really doing to make sure it's properly protected. Another kind of area that businesses get into that comes up for IP, for AI, ML businesses that we talked about already a little bit, is the data privacy kind of situation. So what are some of the common data privacy pitfalls and results that we see with AI, ML businesses? Lack of appropriate privacy policies is a big issue, particularly as more and more states are passing different privacy laws. California has two. We have the California Consumer Privacy Act. We passed one in November 2020, which was a new one, which is going to go into effect in 2023. Virginia has just put one in place this past year, and Colorado just a couple of months ago put one in place. So you're starting to have a little like piecemeal different privacy laws that apply based on what you're doing with data and all of that. We also have, if you're dealing with the EU, we have GDPR. And then if you're dealing in the medical, like healthcare space, we also have high-tech and HIPAA. So you need to be making sure that, one, you have privacy policies in place, and then you're complying with privacy laws, because these, again, are creating large liabilities. And then if your customers will also require you to be compliant with all of this. So you need to be able to go to, for example, if you're in the medical space, to be able to go to your client and say, hey, I'm complying with this. They will often ask for different types of auditing. So a lot of clients have like SOC 2 audits. So you need to be taking an active role on the data privacy and cybersecurity side, investing in that and making sure you're protected, both with your customers, but also with vendors, again, like we talked about. So the common pitfall, as we talked about, is failure to have vendors and subcontractors comply with privacy laws. So the common results of failure to having the appropriate provisions around data privacy and cybersecurity is you end up with regulatory actions and fines. You have private rights of actions against you. You have loss of deal flow because you get a lot of bad PR that arises from this. So you're obviously not going to be as competitive in the marketplace. You then also have to cover breach notification and mitigation costs. So those are, again, large liabilities for a business to face that could put a business out of business. So that is why it's so important to be proactive on addressing data privacy, cybersecurity in your agreements and in your technical preparation. Another kind of area that businesses get in trouble is liability pitfalls and results. So this can take various forms. So one of the forms is overpromising in deal negotiations or marketing materials. So this is something where, I've seen a situation on clients who have been on both sides, right? They have had a customer who's been unhappy, who has come back and saying, hey, you guys said the product was going to perform in a certain way. It hasn't, as well as clients who've had vendors they felt who've done that. And this exposes a company to fraud and false advertising claims. So it is very important for a business to be actually having, discussions with their salespeople, having processes and procedures for what salespeople can say in place so that there is no overpromising going on in these deal negotiations or marketing materials. And the business actually is putting an accurate presentation of the offering out into, to their customers.
Excuse me, Morvareed, you have 10 minutes remaining.
Okay, so I'm almost done. So I'll finish this and then we'll go to questions. Another common situation is making strong statements when angry. So this will expose a business to exposure to like slander, defamation, libel claims. This often takes the form of maybe an employee who's left or who's been fired, and they have another employer kind of call up for a reference or something, and someone is just kind of angry and says some very strong statements. Again, before you make any such statement, it's good to kind of get counsel with your attorney. Do you really need to go that far? Do you really want to expose yourself to some kind of potential claim? Or maybe you're just going to say something a little bit more neutral. So again, good to kind of go to your attorney before you go off and say something really strong out of anger. And the other kind of issue is agreeing to improper scopes, types, and amounts of liabilities. I see this often, again, when people want to close a customer deal, particularly if it's a lower value deal. Something businesses need to realize is that a low value deal does not mean low risk, right? It could be low value monetarily, but it could have a large risk, such as on the data privacy or data breach side or something like that. So businesses need to realize that they still need to do the legal analysis on all deals, and having that heightened risk profile from those high risk but low value deals does lead to the business valuation being driven down, insurance premiums going up, and potentially resulting in bankruptcy. So top takeaways: have well-drafted and tailored agreements in place, maintain business records, protect your IP and trade secrets, and make sure you budget for advisors to protect your business. So I'm happy to take questions now.
Thank you, Morvareed. Looking at the Q&A, so I had two questions that are in the Q&A. So, well, it's one question really. So knowledge workers such as data scientists or programmers are often asked to sign restrictive IP agreements before employment. So two questions. What options do they have to protect their rights? And two, do you think labor laws need to be changed to help protect them?
So I think one of the situations is if you're entering into some kind of relationship with a business, as whether a consultant or employee, it's good to get an attorney to review that as well, just to make sure it's not overly broad in terms of what it is contained within the agreement. So particularly if you're looking to continue to operate in that space or do some kind of, I have some clients who do side businesses on top of their employment. So it's important to review all their employment related agreements, as well as other kind of employment handbooks and all of that, to make sure that they have the ability to do what they want to do. But it is also important to keep in mind, if you are an employee, your employer does own, obviously you're going to have to keep things confidential that you're working for there. They're going to own a lot of IP that you're creating, because that is the point of employment. So I don't kind of see that changing, because that's how businesses create value, and that's what they're paying employees to do. So, that's particularly if you are an AI ML business, that's why it's important to get the right agreements in place. Otherwise, you do get situations like I have seen multiple situations where former employees have run off with intellectual property, including taking hard drives, and the employer hasn't had the appropriate agreements in place. So it's been a messier situation versus if there had been the appropriate, employment agreements, the appropriate employer handbooks in place and all of that. So it wasn't you didn't have to have a prolonged dispute over who owned what and getting access again to the IP that somebody ran off with.
Great, thanks. So we have another question from Cervantes. When and how do startups start engaging AI ML lawyers, deal by deal or something else?
Yeah, it's important to start having those discussions from the start. So, I'm as involved as my clients want me, so I can be involved, deal to deal. I can help make my clients their template agreement they use with customers. So it's as involved as they want. But I do say it's best to get that counsel involved early. So I will use a specific example. Someone who had reached out to me to get assistance. They'd been operating their business for a year and a half. They had spent the time and money on consultants and building out a hardware prototype as part of their offering. And by the time they came to me and I did the legal analysis on their business, it became clear that the business model was illegal. So they were now faced with the choice of having to spend the money and time to revamp their whole business or to shut down. They decided to actually shut their business down. But all of this could have been avoided if they'd come to me at the very beginning and said, hey, can you help and analyze my business model? Would likely have taken a couple hours, and I would have been able to tell them this is a problem, and they would have been able to shift their business model before they actually made the investment of time and money. So that's why it's so important to get assistance early on, because as a technologist, as a business person, you don't know what you don't know, and you don't know the legal. So you don't know how to get the right legal compliance in place, which is particularly a big issue in AI ML. You don't know different kind of issues that may come up on the IP side with agreements. So you really should be getting that assistance from the beginning to get I would say one of the biggest priorities for the business is that customer agreement. So investing in getting a good template for your customer agreement is very important.
Great. So next question is from Preet. And he's saying that patents are expensive to maintain and may be difficult to implement in California. Are they a recommended path for AI and ML businesses?
That is something to talk. I'm not a patent attorney. I am kind of contracts and counseling around data privacy, IP monetization. So that is something you explore with a patent attorney. And if anyone needs one, I have colleagues I can introduce you to determine whether you need to go the step of actually getting a particular patent in a specific situation, or it rather makes sense to protect it just by contracts alone. So again, there are different ways to protect IP. It could be both the registration and the contractual, but you're always going to need the kind of contractual provisions in place to try to keep it in confidential and protected. So that's something that you would work in conjunction with your contracts attorney and your patent attorney.
All right. So we have a couple minutes left. There don't appear to be any more questions. So I will ask kind of, more general ones. So given that, this is a thorny area, right? Because it's so new and gray. And given the highly specialized nature of the legal field, right? Like you say that practitioners are very specialized, right? It may be very difficult to find the lawyer that is appropriate for, a given situation, right? So how would you advise, the technologist whom, as you say, is not versed in this, right, to be able to find the right legal advice from the right people?
Yeah, I've found that there are not a lot of real kind of tech attorneys who understand all this. So, it's finding the couple of us that actually understand the space, have worked with AI, ML businesses, and kind of understand what's going on. So that's kind of been my experience. As I said, I've had to educate other attorneys. I've done continuing legal education classes for them. I've had to educate opposing lawyers on the other side of a transaction, because so many, the legal industry in general doesn't understand technology and how it operates and all of that. And you really need to know someone who kind of understands the different components of what goes into the functioning of tech businesses, and particularly AI businesses. And, that's, I guess asking one way to find good search parties is just, people you've seen, or you've, asking for introductions from people you may know who are working in the same space.
Great. I think that brings us to the end of our time today. So thank you, Morvareed, for your presentation and the attendees for all the questions and interactions during the session. It was very enlightening. You can contact the speaker directly if there are any further questions regarding this topic. And please provide your feedback using the form in the chat box. And thank you, everybody, again today for joining today's presentation. And I hope you have gained some insights from this session. So have a wonderful day, and thank you all for being a part of this year's DataCon LA. Thanks again. Bye.
Thanks. Thanks, Stephen.
You're welcome.
Yeah, good seeing you. You too. Bye.